That said, I now recognize Mr. Lawrence Martin, the attorney at the Halverson Northwest Law Group and representing the National Water Resources Association from Yakima, Washington, to testify. You're recognized for 5 minutes.
Members of the subcommittee, thank you for giving me the opportunity to appear today. My name is Larry Martin. I am here on behalf of National Water Resources Association. NWRA represents state associations, irrigation districts, other water providers, and their collective interests in the management of irrigation and municipal water supplies in the western states. We fully support the need for keeping our water safe and clean, not only for purposes of crop production, but also for drinking water and fish and wildlife habitat. I will focus on the proposals regarding the definition of the waters of the U.S. and management of U.S. Forest Service groundwater. But I must mention that these are only two of the pending rules. Water users are also struggling to review and comprehend Forest Service directives on BMPs and ski area water rights, and 3 other draft rules and policies related to the Endangered Species Act. All of these proposals have the potential to seriously impact water users. These are not easy reads. They are highly technical documents that cite numerous studies. The proposed waters of the U.S. rule continues to expand federal and legal jurisdiction to the detriment of local communities and water users who rely on the efficient delivery of water for crops, jobs, and our economy. The agencies may claim the proposed rule will provide clarity to regulated entities. That assertion is contradicted by the imprecise terms contained in the rule. Despite its length, the proposal creates more questions than answers on whether a minor body of water is a water of the U.S. and has the potential to expand federal jurisdiction over thousands, if not millions, of acres. Compliance with permitting requirements can take years and cost many thousands of dollars. These costs cannot be avoided because the Act imposes criminal liability and civil fines on a broad range of ordinary activities. We do commend the agencies with proposing exemptions from federal jurisdiction. However, the uncertainties in some of the definitions provide only vague answers as to whether certain waters will be excluded. Every year, irrigation districts, water companies, and farmers perform routine maintenance work on thousands of miles of canals and ditches. If required to obtain a permit for each such activity, these routine activities would become anything but routine. One of my clients is the Sunnyside Valley Irrigation District in the Yakima Valley. It serves nearly 100,000 acres of the most productive farm ground in the nation, growing hops, apples, cherries, grapes, mint, and other important food crops. SVID has received numerous awards for its environmental and conservation activities. Its conservation project has increased efficiencies to its farmers, plus will return over 43,000 acre-feet per year for in-stream flows to the Yakima River. Despite its leadership, SVID was the unfortunate subject of the uncertainty regarding waters of the U.S. SVID was performing routine maintenance to fix an erosion and drainage issue in a ditch. This activity is likely performed on an almost daily basis by other irrigation providers in the West. The Corps advised SVID the ditch was subject to jurisdiction and was told to return the ditch back to its original but not working condition. The Corps added that in its opinion the work performed on the ditch was not necessary. After 4 years of negotiation, numerous meetings and trips to Washington, D.C. to meet with EPA and the Corps, and the issuance of a new regulatory guidance letter, SVID was eventually advised its work on the ditch did not require a permit. Similar situations to SVID's experience will continue to occur until there are clear definitions distinguishing between jurisdictional waters. Irrigation ditches were never intended to be considered a water of the U.S., and the final rule should expressly provide that exclusion. Similarly, reclamation and reuse facilities should also be exempt. I have submitted photos of reclamation facilities in California, which under the proposed rule will likely now be jurisdictional. NWRA is also concerned with the new Forest Service groundwater directive, which is contrary to long-standing federal policy respecting the roles of states and private property rights in regulating groundwater. This directive was developed without any meaningful outreach to water users, many of which have existing water systems on Forest Service lands. The directive would place additional permitting requirements on water infrastructure and will make meeting current and future needs and responding to climate variability more difficult and expensive. We are also concerned that the Forest Service will attempt to tie permit approval to the modification of a state-issued water right and has the real risk of jeopardizing the integrated plan in the Yakima Basin. NWRA members will continue to meet their obligations to provide an efficient and safe water supply and remain dedicated to the protection of our natural resources. Unfortunately, the rules expand federal jurisdiction, imposing additional regulatory burdens on water suppliers. On behalf of NWRA's members, I thank you for your attention to the critical water supply issues.